Now we come to the time where we're thinking about whether or not we can bring a case on constitutional grounds. The most readily used examples of this are rights-based litigation. Our first question is always going to be whether or not a matter is justiciable. Justiciability refers to whether or not something is capable of being determined in a court of law. So justiciable means being capable of being determined by a court of law. Sometimes it means that the subject of the action or the application is only able to be adjudicated in a court of law. An example of this would be the validity of a will, where that cannot be mediated it cannot be mediated out, and there cannot be arbitration to discuss this. Only a court can decide it. So when we're talking about rights-based infringement, we're also talking about whether or not a court has the ability, and most cases it does, have the ability to decide on what is and is not justiciable. So what are the main components of determining justiciability? The first is locus standi. Do you, or rather your client, have the ability to stand in court on this particular matter? Is the party that we're bringing this application against the correct party? Would the relief suit the party that we're bringing the relief against? So, for example, if we're bringing an issue relating to refugees, does it help us citing the premier of a province, or do we need to go and cite the Minister of Home Affairs? The next question is ripeness. Now, ripeness refers to whether or not a matter is ready to be adjudicated in court. Ripeness, an example of ripeness would be if something bad has happened and we need a remedy to fix it. So if a right to education, say, is being infringed or has been infringed, then the matter would be ripe for hearing. The court does not want to be brought in for trivial matters. We don't adjudicate, or the courts will not hear a matter that's purely based on academic thought processes. So if you find that a provision or a regulation is unconstitutional because it may lead to an infringement of constitutional rights, the matter is not ripe. You would have to actually show the prejudice, not the potential prejudice, in order to have your matter fit for hearing. The opposite of ripeness is mootness. So I'll give you an example from my real life. I was approached by a matric student who was being prevented from attending her matric dance on the basis that her parents had not fully paid her school fees. We had to bring an urgent application to compel the school to allow her to attend her matric dance. And by the way, for anyone wondering, it was a public school. So had we waited and not brought this urgently, the matric dance would have happened already and we wouldn't have had an application to bring. It would have been moot if we had brought an application on the infringement post the fact, if the remedy was for her to attend her matric dance. Be happy to know that she was in fact able to attend her matric dance by court order. Then we've got to think about whether or not this is a real case, if there are real infringements, or whether or not the infringement is sort of loosely linked to the issues that we're bringing in. And I will have to say that, especially in urgent court, you see a lot of loose arguments being brought in to assist an applicant in bringing a matter on urgency, but in fact it is not a real matter, and there are some trivialities. So we call this the de minimis rule, where a court will strike an application or an action on the basis that it is trivial, academic, not ripe, or moot. Something to consider. So the one thing that I want to go back to is Locus Standi on constitutional issues. Prior to the Constitution, South Africa had a very, very narrow view on standing. You only had Locus Standi if you were directly and specifically affected by a decision or conduct. So only the person who was directly affected had locus standi to bring a matter to court. Now that the Constitution exists, we have a much wider scope for locus standi. People can bring applications in their own interest on behalf of a group of people, classified or unclassified. This is referred to a class action. They're very difficult. I'll talk about them in a little bit. You can also bring an application on behalf of an association or an organization, or you can bring an application in the public interest. Now, this is the really interesting one, because you can say, for example, a petrol company is affecting the environment, and the conduct that they're doing, polluting the wild coast, for example, is causing environmental degradation, and this is an infringement on everybody's right to a healthy environment. So that's an example of an application being brought in the public interest. Another example of an application being brought in the public interest was the Treatment Action Campaign's case in 1994, where they brought an application to compel the government to provide antiretrovirals to pregnant women. Perhaps you remember this, perhaps you don't, but the Department of Health at the time said that there was no AIDS crisis, and although antiretroviral medication was being offered to South Africa for free, that because there was no AIDS crisis, there was no need to bring in this medication that could save mother-to-child transmissions and stop a new generation of people being born with AIDS. The organization didn't have a direct and substantial interest because organizations don't contract HIV. They were bringing the application in the public interest, and they were wildly successful. So this is the sort of matter that Locus becomes broader. It illustrates that Locus becomes broader and is so much more impactful as a result of that. It was one of many, many, many constitutional court applications brought in the public interest by a civil society organization. Other organizations that have been very prolific in terms of bringing applications to the Constitutional Court have been the Center for Child Law, the Scalabrini Refugee Center, and in fact there have been many, many, many. This is all to illustrate that you can view locus standi more broadly than you were able to in the past, and I think it's absolutely wonderful. So I wanted to speak a little bit about that one finicky section, which is the issue of class action suits. Class actions are actions, not applications. So they're brought regarding a material dispute of fact for a claim sounding in money. The jurisprudence and procedure surrounding class actions is quite new and quite interesting in South Africa. The most recent class action that has happened was the silicosis and asbestosis case, where a class of people who were adversely affected by contracting silicosis or asbestosis while working on mines and their descendants were brought claims for damages against various mining companies. But before they could proceed with the actual case, the actual action, an application for certification of the class had to be brought. That was an application which shows that there is a direct and substantial interest between the parties, and that although not all parties are named, that the dispute relates to all of them. So we will never really know the exact extent to which silicosis and asbestosis sufferers have died in poverty and uncompensated by mining companies. But it did take 12 years for the application to come to finality to certify the class. So if a client comes to you and says, I would like to do a class action, you need to caution them that this is a long, lengthy, and massively expensive exercise. Class actions are rare, and they're rare for a reason. The reason being they're difficult to do, require huge amounts of resources, and not necessarily capable of being successful. If you want to look at a law firm that's been wildly successful in this, it's the Richard Spoor Incorporated. They did the asbestosis and silicosis case, as I mentioned, but they've also they're also looking at class actions relating to the coal industry. There is a lot of scope for class actions in the country if we can get the mechanisms right. We think about how many impoverished and affected people there are in South Africa who won't have access to justice and won't have access to resources, but could benefit if there was a class action brought in their name. It is not the sort of law that can be done by one person. It is definitely the sort of law that requires teams of people.